Welcome to Vacation Home Masters, the podcast. You can find us at vacationhomemasters.com. And today, given all the news of the recent coronavirus outbreak that's going on all over the world, it's beginning to affect us here in the United States. So yesterday, which was March the 10th, 2020, the Florida Vacation Rental Managers Association had on their webinar guest speaker Keith Brady from Keith Brady Law, or keithbradylaw.com. You can look him up and find him. Keith is considered the preeminent attorney expert on vacation home law here in the state of Florida. He's been in our industry for literally decades, and that's his area of specialty, which is a very rare specialty for an attorney, but it's what Keith does. So without further ado, please excuse our sound quality as it's a recording of a recording. Let's listen to yesterday's webinar.
All right, good morning, everyone. We're going to get started in just a second. Just to give you some information on the webinar today, we'd like to welcome all of you. We have over 200 registered, so thank you for joining in. This will be recorded. It will be on our website within a couple of hours after the webinar finishes. It will be at fvrna.org, so you can always check that website for more information. We also have on that website a great COVID-19 page that we're keeping up to date so that you'll get more information on the coronavirus and any information related to it as things progress. This webinar itself is only going to handle a certain amount of things. It's going to be for cancellations, legal requirements, conflict avoidance with relation to any guests that are trying to cancel related to this virus issue. So that is all we're going to discuss today. There's a lot more on our website that you can go to. We have a chat format that is opened up, so you'll be able to post questions on the chat anywhere during the webinar, and we'll try to get to your questions in the order that they came in. Like anything else, this has caused a lot of hysteria in the industry, and what we're trying to do is keep people calm and understanding the exact situation that we're in. This is treated just like any other influenza virus or flu outbreak that we've seen in other areas. It takes all the regular precautions. Wash your hands regularly, sanitize, stay away from people that are sick. If you're sick, stay home from work. It's really those basics that we're seeing coming out of all the health agencies. So the Florida VRMA now is working closely with the Florida Department of Health, and we're going to have weekly meetings with them so that we can stay on top of all the new developments on this. And in turn, we'll keep all of our membership up to date on that as well. So just keep checking our website and you'll see more information on it. One of the things we found in these instances before, just like when it was hurricane preparedness, or it was the red tide or blue-green algae or whatever it is, people get into panic mode. We want to make sure that people understand the basics and the facts, stay away from the propaganda and the press, and make sure that they understand exactly what's happening. And then you can in turn relay that to your guests as well. So a lot of those things we'll be working on with all of our industry partners moving forward. We have some data coming out from Key Data to show where the bookings are as far as vacation rentals, any slowdown, any cancellations, we'll share that with you. So a lot of this information is going to be found on our website and our COVID-19 website that we've set up on our pages. So without further ado, we're going to get started. We ask that if you're not muted, to remain muted throughout this so that we can make sure that we have a good, clear connection with everybody. So it's my pleasure to get this started and introduce our speaker today, which is Keith Brady. Attorney Keith Brady from Keith Brady Law is going to be facilitating this. Welcome, Keith.
Thank you. Good to be here.
So I'll give it over to you, Keith, if you want to kick it off and get started. I know you've got a lot of information to provide, so we'll go along, and if any questions come up, I'll just hand them over to you.
Okay, thank you, Dennis. I'm going to talk about the law today. I'm going to limit my comments to the law and ask that in return when we get to the question and answer section that we focus in on the law, and for another day we'll save the idea that we all understand the low probabilities, we all have compassion for the few that get coronavirus, and there's an awful lot of business challenges. But for today, let's focus in on the law. And next slide. So I'm going to give a brief overview. There is a lot of information, but out of respect for your time and for clarity, it's going to be a very brief presentation with the remainder of the time reserved for question and answer. So first I want to go over the contractual duties. And there's 4 different areas of legal requirements, the first of which is contractual duties. To understand what your obligations are, you need to first look at your own cancellation policy. And I won't get into too much detail with that, but I mean your main cancellation policy of days in advance, the retirement of any advance payments, etc. That's going to be the first thing that governs what you can do and what you can't do regarding cancellations and requested cancellations due to coronavirus. The second thing you want to look at is your force majeure clause or the alternative. So force majeure is a term that probably most of you are familiar with and probably most of you have in your contracts. And it will read something along the lines of, if there's an unavoidable catastrophe that interrupts the expected course of events, then they're entitled to cancel. So you may want to read what you have as far as emergencies or force majeure, and you might find that by contract, this event does qualify for them to be allowed to cancel with a full refund and no penalty. Now, the modern trend is for alternatives to force majeure that are much more narrow. So, for example, instead of saying if there's any kind of unexpected catastrophe, you might have a better, more modern term in your agreements which says that only if it rises to the level that includes such things as, say, a mandatory evacuation or a travel ban, that then and only then are you required to give refunds. So start by looking over your contracts and seeing what it says, A, with your general cancellation policies, and B, look for a force majeure or emergency policy. Would be in the same area that you might address hurricanes and red tide, for example. Third area with contracts is the third-party contracts. Bear in mind that you have contracts with homeowners, most of you do, and I've seen wording that is, I want to say, unnecessarily generous. It will say, for example, that you pledge and you have a duty to exercise all reasonable efforts to maximize occupancy. What that would mean, and that would be in a section where you talk about marketing, etc. If you put something like that, just be on guard that you didn't obligate yourself contractually with the owners to make sure you don't give out any refunds or allow any cancellations unless required to, and then turn around and do it and leave yourself liable to the owners. As we'll touch on later, it's not that they're going to sue you, it's that they might get mad. You have contracts with online platforms, or at least most of you do, and you want to be aware of what they say. For example, Airbnb allows cancellations based on date-specific travel bans, and they're posted on their site. And HomeAway travelers will automatically get the traveler service fee refunded, which they otherwise would not be entitled to, but they are accommodating people during this time. next slide is the second of our four legal requirements, and it's statutes. And this is intentionally blank. For any of you that wanted to find out if there's any statutes or laws that govern what we do with viruses or in this type of situation, there's not. If anybody has questions, we'll again have a question and answer session. Next slide. The third of the four legal requirement slides are the case and common law. Now, little background, when the courts decide something, or there's a law that's so old it comes from England, 500 years old, it's just as powerful and just as enforceable as if it's in the statutes. So these laws are rock solid. I've certainly had cases based on these laws. Frustration of purpose, impossibility, and impracticality. And what these say is that, just like force majeure, these are reasons that even though you have a binding contract, you're allowed to get out of it if you can show one of these three circumstances. Frustration of purpose is an unforeseen event that undermines the party's principal purpose for entering a contract. We've seen this with high levels of red tide. Impossibility is circumstances that made it literally impossible to perform contractual duties, such as a travel ban, or you were hired to pay a house, but the house burnt down. Just can't paint it anymore. Impracticality means it's not quite impossible to do, but boy, it just doesn't make financial sense anymore. It's too difficult or too expensive. The airfare prices tripled, or we've seen more than once in Florida where a bridge was out and it just made it impractical to have to go miles and miles around or use a ferry. So if there's strong enough evidence that the contract was enforceable, but it just doesn't make sense, it's too hard to do or even impossible to do, if we had known this, we would have never entered it, then they have a legal right to get out of the contract. And on the fourth slide for legal requirements, we'll forward to that, there's emergency orders. Right now we have none, but they're issued by the governor. You'll see them with regularity for hurricanes, and they typically cover mandatory refunds in these emergency orders. I think that the governor is on the complete opposite side of the fence. He's on our side. We want to encourage travel. But that's where we would find our law, not in statutes when it comes from the state, but from an emergency order, where, for example, if there was a huge outbreak in Sunnyside Beach and it was just rampant, they might issue a quarantine for that little beach village. And I doubt this would happen. I'm just trying to give an example. And then once it was an emergency quarantine or emergency evacuation, it would, historically, you could count on it also requiring all of us to give refunds. Next slide. So now we know what the law is, but we'd all be fools if we marched off to battle, to conflict, knowing what our rights are. And we're going to fight that to the owners, we're going to fight with the guests, and we're just going to fight about what our legal rights are. It's not cost effective, it's not good for business. So any reasonable legal advice has to include to work hard to avoid the risk, avoid the conflict. So there's two major areas of risk. The one is chargebacks, the one is lawsuits. Now, chargebacks historically are determined without a strong adherence to exactly what the rules or the laws are. If it's a sympathetic story, they'll tend to side with them. So you want to be cautious about people's ability to win a chargeback, even when you and I will agree that's simply not the rule. We have a contract and all. So it's a little early to determine exactly where the credit card processors are going to fall on this. But bear in mind that that's a risk, meaning it's not good enough to say that we know the law and the law says we should win the chargebacks. It's good enough when we realize that we're also not losing chargebacks. And again, we have the rules on our side, but they have sympathetic pleas on their side. So best advice is let's try to avoid chargebacks and not be so satisfied that we should win them because we don't know that we would. Lawsuits. Now, when it comes to lawsuits, if a homeowner or a guest, and I don't want to mention the owners too much, it's mainly the guests, if they threaten, well, I'll sue you if you don't give me my refund, bear in mind, again, we may be in situations, and we will often, where we have every legal right to simply keep their deposits, refuse to cancel their reservations. And when they threaten lawsuits, bear in mind there's a huge cost bar. They would have to hire a Florida attorney, and the Florida attorney would invariably cost more than they could possibly win for the guest. So let's come back around to what's the point then. Number one, overall, the law's on our side when it comes to not having to offer cancellations. The law's on our side when we should win chargebacks. And the law's on our side when it's too expensive for people to sue us and win that way. So we're in a strong position when it comes to the law. So we move on to the next topic on the next slide, which is that, okay, if the law's so strong for us, is that all we need to know? No, not necessarily. Think about negative social media. Think about regular guests that come every year and you lose them. Think about first-time guests that could become returning guests, not only returning, but returning and referral guests. So this is where any good legal advice incorporates good business practices, which state, even if I can win all these conflicts, is it really in my financial best interest? So I want to encourage everybody to negotiate. Consider, if you're not going to grant a full refund and a cancellation, that you'll offer a partial refund and let them know, hey, you can't sue me, it would cost too much. Hey, we've got every contractual right to not allow this cancellation or give a refund. The odds of coronavirus are literally 1 in a million in that area. So it just doesn't warrant giving you a refund for your unjustified fears. Offer rescheduling versus canceling. Offer partial refunds with credits, meaning some be creative, some creative solution where I'll give you, half of your money back and keep the other half towards a future reservation. And to be clear, if you ask me, well, why would I do any of that? I would do any of that if I have more money in my pocket in 2 years rather than less money. I could give a hoot what my legal rights are. I want to know what QuickBooks is going to say at the end of 2021 when I add up missed opportunities. Preempt demands. Contact pending reservations now. Maybe use a little humor, no off-color humor, but, let them know that everybody's off the cruise ships and coming into vacation homes, because it's a smart idea. Not my idea, by the way. That came from someone else. Let them know what your policies are. Even remind them that while there's no cancellations available, we want to encourage you. We're open for business, and here's a nice picture of Disney World or a nice picture of the beach. And just encourage them. You have an open door now before their neighbors get to them with their fear tactics. And I had mentioned in the highlighted, to highlight an agreement, and don't be afraid to send them that and let them know, listen, you can't cancel, but you don't want to anyway. Come on in, the water is fine. It's sunny, warm water, great time to come. And on what I'd call a minor note, account for the cancellations properly. Unless you have, block reservations with the tour operator and or some travel channel is asking you to guarantee availability, the cancellation penalties are not taxable. For almost everybody on this call, the cancellation penalties are not taxable, but unreturned deposits are taxable. So it's a minor point, but it's definitely worth mentioning today how you handle the taxation with any cancellations. And that, if we move to the next slide, that covers everything. We've gone over the law, we've gone over the with the 4 areas of law, the contracts being the most important of them. And we've gone over the idea that notwithstanding what our legal rights are, what are the best practices to address this? So again, in summary, yes, I'm compassionate for the few that get coronavirus. Yes, I understand how low the probabilities are and how we're all encouraging travel. Yes, I understand there's it's very tough business challenge, but I wanted to focus my comments and today's webinar on my area is exactly what is the law regarding coronavirus and more specifically cancellations. And so with that, we open it up to questions and answers.
So Keith, we've got a question here. Can you give an example of a difference between a cancellation penalty versus an unreturned deposit?
Yes. A cancellation penalty is worded as a cancellation penalty in the contract. So there's contracts, there's a real power to the wording. And so you can tell a cancellation penalty by it being worded as a cancellation penalty. If somebody just makes a non-refundable deposit and walks away from it, then it's taxable. If it's a cancellation penalty, it's not. So it's all about exactly how it's worded. And just to put it a little more teeth into it, to avoid taxation on money you retain, you have to have write in your contracts that this is a cancellation penalty.
The next question, Keith, is the state of Florida in a state of emergency?
No, not a state of emergency, and nothing that affects today's webinar topic. The most recent we saw is the state put out a advisory that if you traveled abroad to self-quarantine for 2 weeks, then they came back and corrected it to say, well, only certain countries like Italy, Iran, Japan, South Korea, and China. But there's nothing that affects today's topic, nothing that affects reservations and cancellations.
Yeah, and I think that the governor issued a public health emergency, which is a little different than the state of emergency.
Right.
Next question is, so to sum it up for users of VRBO and Airbnb, is it okay to say we are following the VRBO Airbnb policies on this and limit our action to those that Airbnb, VRBO are enforcing? Meaning if Airbnb allows full refunds to guests from Italy, then we do too.
Yes, and let me go back a half step to correct the state of emergency. Whatever state of emergencies the governors put into place, none of them are hurricane-like state of emergencies, which we want to keep an eye on, which would state that we're required to give refunds. That's what we want to be aware of in regards to today's topic. The state declaring emergency, which means they're going to rally assets to address the health crisis. That's another issue beyond the scope of today's topic. Now, back to this question. The answer is, well, certainly you want to comply with anything that you're required to comply with Verbo and Airbnb. But do you want to maybe comply with more beyond that? Yes. You may have to comply with your own force majeure and cancellation policies in your contract. Later, you may have to comply with the governor's emergency order. And regardless of what you're required to comply with, again, best practices are always to consider what it means from a business standpoint. And just to give you one strong example, if you have a family that comes every year and they say they want to cancel this year, you might think twice about losing a friend. And
in the state of emergency,
yeah.
So with the state of emergency, just so much different than what we've seen with hurricane state of emergency. They're basically saying, get out of Florida, there's a hurricane coming. In this case, they're just preparing for, correct? In case the virus spreads to a certain level, right?
Well, yeah, and you'll pardon me if I'm not astute when it comes to health industry state of emergencies, but clearly the governor's state of emergency addresses hospital preparedness and chains of supplies for testing and putting orders in for hospitals being required to get testing kits and best practices that hospital workers have to wear masks. Those things are all addressing from a medical standpoint. But again, we're not here as doctors, we're here today as VRMs addressing what the governor has said that affects us. And right now the state's policy is to please keep traveling, and the risk is negligible, so come on down.
So Keith, another question that came up was on travel bans. If they have a travel ban, let's say they're coming from Italy, and Italy says do not travel, but they want to travel anyways to the U.S. Is that in some way something that a property manager could use to say they're not going to refund you the money, or you can't come, or how would that be handled?
Yeah, there's two parts to that answer. First of all, if we have a travel ban, which we do for certain countries and certain parts of countries, and you're not allowed to come here from there, then you're required by law to honor that travel ban. Number two, say we didn't have a travel ban, but you start hearing about a bunch of coronavirus from Portugal, and you want to stop somebody coming from Portugal, then it would be governed by your contract. And your contract may reserve the right to refuse to do business with anybody, in which case you can refuse them. Or it may not reserve that right. It might say to the contrary, that you have a written contract where you're obligated to provide accommodations, and then you are required to do so. So, number one, look at any government travel ban requirements, and number two, look to your contract. On a minor note, I'm not recommending that anybody breach your contract, but bear in mind that if you had a foreign national traveler and you just canceled their reservation, or they canceled it and you didn't give their refund, meaning in one of those two ways, you breached the contract, either by not honoring their reservation or you breached their contract by not giving them a refund when they didn't honor it. There's little they can do because it's too expensive to sue you here. So your bigger concerns would be A, chargebacks, B, negative social media, and C, a loss of returning and possibly referring clients.
We've got another question, Keith. If a property manager has a cleaning crew that goes in and someone gets sick by cleaning a room that someone was infected, can they get sued for that, or how do they protect themselves on that end?
It's a good question. It's a basic legal concept is negligence. We all know the law, and it's a surprisingly simple area of law to explain. Negligence has four elements. Number one, you had a duty. In this case, you had a duty to make sure you took reasonable precautions to make sure people didn't get coronavirus, or for that matter, flu or whatnot. And B, you breached that duty. C, it caused the damages. It was the cause of the damages. And D, a little redundant, there were damages. It was the cause and it was damages. So duty, breach, causation, and damages. So what does it mean here, to put it together? If you think there's a high enough risk of coronavirus, well, forget if you think, if a reasonable person thinks there's a high enough risk of coronavirus being spread to a cleaning crew or even through a cleaning crew to another house, then you would be required to put in special precautions, say masks and hand sanitizer. Right now, I think that any responsible attorney would tell you there's just not that level of risk that requires the extra precautions. Because again, what we know for a known risk right now is that out of 22 million people and with visitors 30 million people, when we reach the point where there's 300 coronavirus cases in the state, then remember that 3 million cases would be 10%, 300,000 would be 1%, 30,000 would be 0.1%, 3,000 1/100%. You see where I'm going? 300 1,000% chance. So legally, it's safe to say that you're not negligent in not taking any precautions. I like precautions anyway because they're free. So my legal advice to you would be, one, tell your cleaners to at least take some precaution, which is, say, to use hand sanitizer before and after each, or wear gloves, or some type of precaution. Two, if you're in an area with active cases, which are few and far in between, like Broward, you might even ask that they wear a mask. Well, then again, if nobody's in the room, that doesn't really make sense. But here's what does make sense. From a legal standpoint, there's an old saying that in this case, the actions or the precautions are secondary, the documentation's primary. So if you have an email or some type of written record where you've told the cleaning staff, hey, just to err on the extreme side of caution, we're going to ask everybody to wear gloves or to wash their hands before and after each house, or something like that. And then what you've done is you've said, well, not only have I met the legal requirement to avoid negligence, but just for the one wacky judge out there, or the one unscrupulous attorney that's going to tell people they should sue because they can win when they really can't, I have this extra line of defense. And I'll say this, that anybody that knows me know that I say the largest risk is the risk of winning lawsuits. We want to avoid people that think they can win chargebacks, think they can win lawsuits, and they can't, but we could have done something to convince them they couldn't, to avoid the whole conflict in winning to begin with. So to restate it simpler, you're not liable because you're not negligent. You haven't breached any duty. Nobody in the world is saying, oh my God, all the hotels and vacation homes, you all need to be wearing masks and doing this and that. Nobody's saying that. So you're not being negligent because you're not doing what the normal, ordinary folks are doing. But call me a coward, but I'm like, you know what? I'd love to have a document that shows that we're taking extra precautions anyway, because that protects me from winning a lawsuit or winning a chargeback, if you will.
And I think to add to that too, like you say, precautionary measures for your contractors and cleaners. On our website now, there's a toolkit, and it's in various languages where you can share that with your employees or your contractors, and it's the basic things they should be doing anyways, just as every person should, to wash their hands and to make sure they're not touching their eyes and nose and whatever. Share those toolkits with them to kind of protect yourself that you made them aware. We've got another question on the platforms. The platforms we know have a cancellation policy, and then also the property managers and owners have their own cancellation policies. Does one override the other?
Does one override the other regarding the platform's agreements and the management company's agreements? Is that the question?
Yes. So if you've got your own cancellation policy and they booked through VRBO, and VRBO says the cancellation policy is one thing, but you have something that's different, which one kind of comes into play first?
It depends. Best practices are to have your contract and to state in it whenever there's conflict with any other contracts, which go beyond the platform's contracts. There could be contracts with other folks, like a condominium association, for example, that you want to put in your agreement that your agreement supersedes and controls. Now, two things I'll point out about that. Number one, if you don't have that in your agreement, then which one supersedes is the guest's choice. The law says that it's up to the guest. Whenever it's an old-fashioned term, ambiguity is construed in favor of the non-drafting party. It just means if you didn't think to put it in there, then the law always favors the consumer. They can view it whichever way they want. Number two, the platforms are going to ask you to honor their agreements. So if they want to allow a cancellation, they're going to do it even if you have a contract that says it supersedes. So it's an area we find we want to be very polite and respectful with the platforms. So we'll put that our agreement supersedes the platform's agreements, and show it to the guests, and then the guest will honor that. But on occasion, when the guest just appeals to the platform and says, hey, we want you to honor our cancellation if you can, we don't go to the platforms and tell them we want them to bow down to us. We understand where we fit in the food chain. So just to restate it, to clarify, number one, if you have a term in your contract that says it supersedes the platforms, it does. Number two, if you don't, the guest gets their choice, but they probably don't know the law that well. And number three, even if your contract supersedes, you still don't want to pick a fight with Airbnb or Vrbo if they want to cancel and you don't. And I will point this out. If you read what Airbnb and Vrbo is writing, it very much makes sense from a business standpoint and coincides with what I'm saying about being business savvy, they don't want to burn bridges with people. They do want to be accommodating when they can. They always have been very hospitable and agreeable with their guests.
So the next question, Keith, is about guests that may be calling in to cancel and they're saying, hey, I just have a fear of flying because of the virus being out there. Is that grounds for canceling a reservation, just to say, I don't want to fly because I'm worried?
Absolutely, it's not grounds. In my legal opinion, fear of coronavirus, fear of flying, or any other reason isn't grounds for cancellation. The only grounds for cancellation are what the contract allows for grounds for cancellation. Bear in mind, the contract's no different than a contract to buy a car or to remodel a house. It's a signed, done deal contract. You're giving me money, I'm giving you a house in exchange. Now, if you want to back out of that, you have to have legal grounds to back out of that. And again, one of them is the contract might say, for example, if you cancel, at least 30 days in advance, you get a full refund. Less than 30 days, you get a half refund. It's governed by what the contract says.
Any instances on what are the grounds for a guest to be able to file a chargeback for the virus? Is there a certain example you can give on that?
We haven't seen statewide any chargebacks that were on the grounds of coronavirus. I presume there will be a large amount of them. I imagine a lot of people will use a pretextual reason, meaning they're afraid of coronavirus, but they'll say it's because of a death in the family or whatnot. And again, we'll cross that bridge when we come to it. Our argument is that they're not entitled by contract to a chargeback, and the credit card companies and the guest's argument is sympathy. And in the past, we found that the powers that be at credit card companies are susceptible to ploys of sympathy.
So we've got another question. Let's say worst case scenario. A guest comes in, they catch coronavirus, they're in your home, and they're sick and they've been diagnosed as being sick with corona. What's the property manager's obligation at that point? Is there some type of disinfection, quarantine, what types of things fall into play?
Well, that's a good question. I'm not sure I know the full answer because I don't think that the state of Florida has. The state of Florida will order quarantines on an individual basis. So, first of all, let me go back to the legal liability. If somebody's in your home and they get coronavirus, they're going to sue the property manager, the online platform, and the homeowner, and a cleaning company, probably because they're going to have an attorney that's very thorough. When they do, great general legal advice. Remember that good insurance is always more important than a good contract. It not only covers any damages, but it covers the attorney also. The attorney will defend you for free with the proper insurance. So you're not liable, but it doesn't matter. Welcome to America. They're going to sue you anyway. And insurance companies will generally settle because it's cheaper to settle than it is to win. So that's the legal liability. Now, if I took a guess, what would happen is if a guest was in a house and they were diagnosed with coronavirus, the state may order them, quarantine them right in that house. And you'll be required to you'll be required to allow them to stay and cancel the following reservations. A little nuanced, but you're probably required to offer the continued rentals at a non-profit rate. That's a little nuanced, so don't worry about that today. And then, of course, when they check out, then proper cleaning would certainly be in order. Probably not worth answering today because the odds of that happening are so low, but almost done the answer, so I'll finish. I would always use a professional cleaning service if there was any question about somebody being sick. If somebody checked out and you had in writing that we had the flu or we had colds, I would hire an outside cleaning company, even if for that home only, just because it's a better legal defense to know it was professionally cleaned by a cleaning company and not our in-house maid service. Just has more credibility. So in sum, if a guest got coronavirus, number one, you shouldn't have liability. Number two, you should be expected to be sued anyway. Number three, my best guess is that they would order them to be quarantined in that house. And number four, I would use an outside cleaning company when they check out.
So we had a follow-up to that, Keith, and it would be, would insurance cover any of that costs if you had insurance in place? But if it had to be disinfected or whatever, loss of income?
Probably not. That type of insurance is available, but it's generally not going to cover a business loss. The homeowners, the way it works is that the first line of defense is the homeowner's property insurance or premises liability insurance. And another free general tip is that there are tens of thousands of vacation homes in Florida that are not properly insured because there's an exclusion for vacation rentals. So the homeowner needs proper insurance, and that's going to cover any premises liability, meaning if somebody got hurt on the property, and that would include meaning if they got sick from a virus on the property. So once that insurance company gets a claim, the homeowner's insurance company is going to sue the property manager and say that we're going to pay out the claim, but we're going to come after you for reimbursement because it's your fault because you didn't clean right. So now you need professional liability insurance, which states that anything that you did was a breach of duty. You just didn't do your job according to professional standards. It will cover you for that loss. So again, insurance is a wonderful line of defense. But unless you have, paid extra for business income protection, it's not going to cover any loss of income.
You got another question, Keith. A lot of the guests that have been coming in for conferences the conferences have been canceled. Do you see a chargeback in the scenario if they're canceling their stay as well?
I always see a chargeback. It's one of the largest divisions of our firm is winning chargebacks. Again, chargebacks can be fought and won, but it's best practices to try to avoid them and winning them. So if people cancel for any reason they're not allowed to and you don't refund them, you can count on a good percentage of them demanding a chargeback.
We've got another question on Airbnb is canceling and issuing full refunds under their extenuating circumstances rules, regardless of what the property's cancel policy is. So is there a way to fight that in any way?
In my opinion, no. In my opinion, Airbnb is an incredible benefactor that's changed our lives, along with Verbo. And the power that they have compared to the power that we have It means that even if we all organized and said, we're going to boycott Airbnb if you don't do what we say, would mean nothing on the global scale. So the idea of doing anything other than telling Airbnb thank you just doesn't appeal to me as a good strategy. That's the way they always were. Setting business aside for a minute, Airbnb is a kind-hearted company. There are such things as really nice companies like Disney and Airbnb and Vrbo, and they're just going to do that because to them it's the right thing to do. I will add on a business note, they're not going to lose a dime by doing that because of the favor they earn with the guests over the long term. So they know what they're doing from a marketing standpoint. And I know I'm a broken record, but I keep coming back to that same point, that winning chargebacks and all isn't always where the money is at. Just add one thing. For example, it's a guest that comes every year.
All right, so I'm trying to skip over some of the ones that look like we might have already answered them here. The last one, we only have one general cancellation policy stating that no cancellation refunds are issued within so many days of arrival. It's in the hurricane policy, but they don't have a clause regarding catastrophic events or epidemics and things of that nature. Can you repeat what the obligation would be by law to issue refunds?
Yeah, if you don't have anything addressing catastrophes, hurricanes, evacuations, red tide policies, then you have not surrendered any of your rights, and your rights are just what it says. No refunds if you cancel less than 30 days out, by example. So that's your contractual right. So if somebody says they want to cancel and you tell them no, you're within your contractual rights. My general advice, though, is to contact everybody now and remind them of that policy, to preempt the objection. It's going to be better received if they receive it before they decide to cancel. And if this doesn't address every cancellation, addresses all the people out there now wavering and getting more fearful every time they watch the news till eventually they cancel. Contact them now and let them know not to fall prey to the fear mongers, and understand there's a no cancellation policy and try to avoid those cancellations. And if you can, let them know that for those of you that for regardless, and these are just the next part is just that I think everybody should do. You maybe even send them a highlighted copy of the agreement, letting them know there's no cancellation. Don't fall prey to the fear mongers, because if you do, you can't cancel anyway. And then for those of you that it makes sense to, and I'm not telling anybody how to run their business, but I know from experience what makes sense to some people is to say that while we won't let you cancel, we will let you rebook, for this fall or something. And why would I do that? I would do that because there's more money in satisfying the customer, or at least that particular customer, than there is in winning these, being able to keep these deposits and have them mad at me. And not to belabor the point, but if you send out emails and talk to people, and people say, some might say, I understand the cancellation policy, and they're willing to give it up. I've twice lost deposits because I couldn't make a trip, once a long time ago, but I didn't complain. I just know I lost my deposits. If they're like that, you don't have to do anything. And if they're like, this is outrageous, how can you not care? I'm going to put negative social media, I'm going to charge back. Then you might tell them, well, wait a minute, I'll make you an offer. How about instead of just keeping the deposit, I let you apply it to a future renter? Does that fit for everybody? No. But it's an idea.
I think you're absolutely right on the preemptive outreach, though, Keith. And if you're in a place let's say Cocoa Beach, I'm making it up, and everybody's loaded up on the beach and everybody's having fun things to do, and why not take pictures that are real time, send them to them and say, hey, everything's great here in Cocoa Beach. Boom, preempt it out, and then make sure that you're ahead of it before they start complaining and looking for a reason to bail out on you. Next question was a question really geared to the other side of this equation. We've been talking a lot about the guest cancellations and what the guest wants and appeasing the guest, but the property manager question is, what about dealing with the owners who don't want them to refund anything and having to deal with that side of it?
Right. Well, I always encourage everybody to, read your agreements and understand your rights and responsibilities. And so no better time than now to do that. See what your rights and responsibilities are with your owners. Again, best practices in contracts are not to put any promises in that you don't have to. That goes into a brochure where we strive to do our best and maximize this and that. But I do see it in contracts. I've actually had lawsuits of that in contracts, and based on that being in contracts. So it's governed by what it says in your contract. Proper contracting gives you the right and authority to cancel and refund in your own discretion. So read what it says, and why don't we add the same advice? Do a newsletter, send a newsletter to your owners, letting them know how you're addressing this to preempt their complaints. And number two, then address them on a one-on-one basis. For those that are fine, case closed. For those, right or wrong, that are threatening to fire you because they're so mad over you canceling a reservation you didn't have to, then you might want to work with them. There's a lot of things you can do, and you don't need my business advice on that, but the business advice that falls under the legal advice category is know that you can, number one, preempt their objections and let them know it's your right. Number two, let them know that you're working hard to convert them to rebookings instead of cancellations. Number three, let them know that you're, taking extra measures for those that had cancellations to make it up for them in the fall. So you're not really losing anything because I'm giving you the first reservation I get in September or something. And just to address it, again, you have the legal rights, but you don't want to use those legal rights to lose. You don't want to enforce them if it's not where the money is.
And I think you're right. I mean, even on the guest side and the owner side, it's really a marketing technique to use. Get out ahead of it and tell them the situation on the ground, because, if someone's living across the country and they don't really understand what's happening in Florida this time, just get the information out there to them and be upfront with it so that you can kind of mitigate the circumstances before it becomes a problem.
Right. And
we've got another question.
And let me jump in real quick, Dennis. And it's fair to say that, well, yes, it's a marketing strategy. It's a legal strategy. When you get out in front of it, you're going to avoid chargebacks, lawsuits, lost owners, lost return. You're going to avoid conflict by getting out in front of it.
We've got another question on travel insurance. If it's found to be guest purchase travel insurance, is cancellation due to coronavirus usually covered under this, even when a travel ban has not been issued? I don't know if we have an answer to that.
I can answer it because the word usually is in there. Usually what's covered in travel insurance is a lot less than people think is covered. Usually what's covered in any insurance is a lot less than what people think is covered. So on the one hand, where we talk about how we want to be kind-hearted and try to work out issues with guests and owners and be agreeable with platforms. And we talk about companies like these platforms in Disney that are very kind-hearted, insurance companies in general. And while I know a couple people that could even be on this call that are kind-hearted people, the policies tend to be very hard-nosed, and they tend to not worry about the kind of thing we're worried about is, oh, this is going to give us bad social media and maybe it's not worth losing a customer. So just by example, travel insurance usually requires a medical excuse from a doctor, and most people that buy it think it gives them the right to cancel, when it usually just gives them the right to cancel for a very limited reason, like documented medical ailment. Just to give you one other example, and I gave one, that homeowners insurance usually does not cover vacation renters. So we've had houses burned to the ground and it's not covered because of vacation renters in there. We've had people killed by a gas fire, by a gas grill explosion, not covered because they were vacation renters. And while we're at it, bed bugs are usually excluded, and so are other things, gas grills, bed bugs, vacation renters. So when we go over the travel insurance, the way they read is it's usually very narrowly tailored to cover a lot less than what you would think. So I didn't need to say that much. What I should have said is this, is my experience with travel insurance is expect them to not cover, expect the following. If you wonder whether something's covered or not, it's not.
All right, I think we've got one more question. So if we have no contracts and only a cancellation policy, and there's a lockdown in our state or our area, can we still refuse a full refund? I don't think we have those situations that are out there yet. But...
Well, there's always a contract, because even if there's not a written contract, there's a verbal one. Or if you mean there's no contract other than the online contract, then it's kind of a funny, doomsday question, but I'll go ahead and answer it. If there's a legal prohibition against travel, then people are entitled to a refund under what's called illegality. Remember the page with frustration of purpose and practicality and illegality. If they can't do it, or in all practicality can't do it, they're entitled to a refund. Now, what I've seen, and I encourage all my clients to do the right thing ethically, and if that's the case, give them a refund. Not to make it about me, but any good attorney will refuse to deal with a company that doesn't refund them when they're entitled by law. But it does happen out there because people know that you can't sue us at an affordable rate if you're in England or Montreal, or anywhere for that matter, even if you live here.
And I think the major takeaway for us here today is, and I can't remember who was quoted saying this, a crisis is a terrible thing to waste. You might want to, at this point in time, look at your agreements and your contracts and everything you have in place, because as we know, a lot of people don't have anything about anything like this in their agreements. So I would say it's a good time to review it and make sure something's in there for the next time, wouldn't you say?
Well, I had a goal to not do anything to promote our business, but the truth be told, my clients don't have force majeure clauses. They don't have any of these troubling things. They're in good shape. We made sure that homeowners all have proper insurance, and this isn't our first crisis. We've learned how to deal with the bed bugs, the service animal issues, and the more traditional areas of liability. So when this came along, we already have the proper contracting defense. But I don't want to be a fearmonger. I want to let people know that generally right now, I don't have a concern about the general market that, oh my God, you're so vulnerable because of your contracts. Quite to the contrary, and I hope that showed in today's call. But on the other hand, are there things you can do with your contract that you should do? And the answer is yes, with a big if. You only spend money on legal services if it has the equivalent of a good return on investment. And contract editing does have a good return of equivalent of a good return on investment, because it protects you not just for this situation, but next year's and the year after. You know, red tide, bed bugs, service animals, ADA compliance, the data compliance, and next January, the Sex Trafficking Act. There's a lot that goes on out there that you really do want to protect yourself for. So, pardon the view of self-importance, but you know, we're convinced we have a good return on investment with our services.
All right, that kind of concludes all our questions for today. Thank you, Keith, for sharing this information with everyone. We just want to make sure that everybody's informed. If you haven't seen, we do have our COVID-19 website that we're going to be putting information on. It's going to continue to change day in and day out, so check on that repeatedly. We're going to have the health department updates on there. We're going to have information on cancellations and booking trends and other things so that you're aware of what's going on in the industry. So everything that we have is going to be going on there. I'm going to put Keith's information in this presentation on there as well. So if you have any questions on legal issues, you can contact Keith. But all this information is going to be on one web page. So we hope you take advantage of that, and we'll keep you up to date. Thank you, everyone, for participating today.
All right. Thank you, Dennis.